That was conducted on June 24th of 2021. Actually, it wasn't. The report was dated June 24, 2021. The interview was on June 4th, 2021. Hayden reported that he gets help from his homework from his mom or his teachers. He resides with his father most of the time because of the ways the timeshare days fall. His preference is to spend an equal amount of time with each parent, 3 days on and 3 days off. I don't know what he means to do with the fourth day, but in his father's home, he says his father and his wife are currently in the process of divorcing. It's my understanding that that has since been finalized. I don't know. I think one of the documents that was stated, or one of the arguments, that it was finalized. The child said that his concern is Dad's respect towards me. He leaves the dishes until I return to his house. He leaves my door open, but he closes his door, and the dog goes through and trashes my room. Hayden rated his relationship with his mother as a 7, saying she's a great mom overall, but a little hard on me. I've been an adult through my double digits. He rated his father as a 5, stating his respect for others. When I was sick, he still wants me to do my chores, and I didn't want to hear about all the court stuff or the negativity about my mom. Hayden reported that his parents do not get along and they communicate via talking parents. Hayden stated, and this really got me. Hayden stated, quote, "I'm just happy that I have only 2 more years left and then they won't have to deal with each other," end quote. Wow. Here's a child that wishes, essentially, he's just wants to disappear. He sounds like he's willing to trade in the next 2 years of his life because of what he's been through. According to Hayden, both parents have used him to relay messages to the other parent, sometimes regarding extra visitation time. Hayden informed that his father has made negative comments about his mother, stating, "Your mother is the Antichrist." His mother has stated, your dad is a liar and a pedophile." Hayden informed that the court case began as a rape allegation towards his father when he was 3 or 4. Then Hayden wants to have the flexibility to call when he wants to. He communicated that he feels he needs someone to talk to, someone to discuss his anger with before it gets too bad. Hayden also would like for either parent to be able to take him to the doctor without the permission from the other parent. Hayden wishes he was in a less stressed environment. His parents' anger towards each other is placed on him. Hayden would like to be able to do sports without complications with his knees. He would also like the freedom to spend time with whichever parent he wants to spend time with. Hayden presented as personable, articulate, talkative, compassionate teen. He appeared to be genuine in answering the questions presented to him during the interview process. The interview process appeared somewhat therapeutic for Hayden, as he used it to express his feelings while answering questions. My impressions from that FMC report were that Hayden sounds like he's a remarkable young man for everything that he's been through. My goodness. He sure does seem to be resilient. He seems to have just accepted the fact that this is his plight. This is his plight in life. And anyway, the way he described his relationship with Dad after reading Dr. Mullen's report and this FMC report, I would have thought that he was going to say, "I don't want to have anything to do with Dad. I don't want to do it. Yeah, I don't want to." But no, he says he wants to spend equal time with his parents. I think that's remarkable. After everything that he's been through, he can still see the good in his father, despite the fact that Mom constantly tries to tell him that Dad's a bad guy, and that his dad tries to tell him that his mom's a bad person. He still wants to spend equal time with the parents. So, ultimately, I have to take a look at this case again, like Judge Steele did, with a determination. I mean, if I were, back up. it is as if I am sitting in Judge Steele's shoes, Judge Forsberg's shoes on this motion. And so looking at it, if there's did Judge Steele or Judge Forsberg, because Judge Steele thought that maybe she wasn't sure whether or not there was adequate cause to have an evidentiary hearing based on the allegations in Mom's motion. She wanted to hear from the boy, so he was interviewed. And then Judge Forsberg said, I don't find that there's adequate cause. I don't think that Judge Forsberg felt like she doesn't feel like she can change custody on the LSV Carucci standard because there's not been a substantial change in circumstances affecting the welfare of the minor child. Because Judge Forsberg felt like, what has really changed? The child is older now. He's more articulate to be able to express his feelings. But is that a substantial change in circumstances affecting the welfare of the minor child? And she felt like that there was not adequate cause to conduct an evidentiary hearing under the Rooney standard. And so now I'm looking at, as if Judge Forsberg's decision were my decision, I have to reconsider that, because I don't think that it's appropriate for me to look at this case as you didn't mention this or imply this, but when you asked me yesterday, Mr. Carmen, if I was going to look at this, as a de novo standard, I don't know that I'm not sitting in an appellate review of Judge Forsberg's a decision. But I think that as Ms. Johnson cited in her brief, reconsideration may be appropriate if the court, and by reconsideration there's case law to tend to indicate that, that's similar in nature to Rule 50, 52B, about amending or altering the decision. So and reconsideration may be appropriate if the court has committed clear error or the initial decision was manifestly unjust. And I think that if I were the person to hear this case, fresh, if I'd been sitting in Judge Steele's, I don't know that I would have made the same decision, but I can't see that Judge Forsberg committed clear error. I don't think that she abused her discretion. I don't think that there's enough here for me to overturn her decision. So I think what I have to do is deny Mom's motion to alter or amend the order, or in the alternative for reconsideration under that basis. However, I think I do agree with Mom in her motion on page 9, where she states that there is a clear issue with the order, as there is no statement regarding the prevailing party or how the determination for the award of attorney's fees was made. I have to agree. I carefully looked at Judge Forsberg's statement where she said that she just basically said, Mr. Carmen, I'm going to allow you to file a memorandum of costs and fees. She didn't explain why. So I think if I'm sitting in reconsideration of her ruling as if I'm her, reviewing this, that I don't see that there was a careful analysis here as to the award, or an explanation, or there are no findings, I should say. I don't see any findings to substantiate the award for attorney's fees. She just says, I'm going to allow you to file a memorandum of costs and fees and leave a blank line, fill it in, and then in the order itself, the amount of attorney's fees was filled in the amount of, I don't have that memorized, I think it was $12,142.12. But I don't see any findings to justify the attorney's fees, so I think that I have to grant the motion, the Rule 50, the Rule 52 and NRCP 50 motion to alter or amend the order with respect to, or in the alternative for reconsideration, on the basis of the award of attorney's fees. So Mom's motion is denied in part, and with respect to the attorney's fees aspect, it's granted in part, and I'm going to reverse the order for attorney's fees. I will allow you to now argue. I will hear from Ms. Robinson first, because it seems like I'm always hearing from Mr. Carmen first. I'm going to allow you to speak, Ms. Robinson.
Thank you. One of our biggest issues with the judge's order was there were so many joint legal violations that you've touched on when you've gone through each of these hearings, Your Honor, that were not readdressed in her decision. So I'm a believer that just on the joint legal custody violations alone, not only did we show that we met the Ellis burden, but I met the Rooney burden for adequate cause to have an evidentiary hearing. She seemed to rely on the report, heavily relied on that report from Dr. Mullen, and that is only one of the best interest factors. She didn't give a best interest analysis behind her decision, which I guess she didn't necessarily need to. It wasn't an evidentiary hearing, but she totally closed down Mom's argument to be able to argue further at an evidentiary hearing. So she didn't go into any of the best interests. She seemed to, as far as Lynn Conant goes, I felt like that Lynn Conant got really kind of derailed in this whole process. Like, she came off this case without really informing anybody she was coming off the case. And I thought like she kind of got derailed at the point where she was so consumed about the cell phone issue and her allegation that she felt that mother was trying to record these conversations. I just don't feel that she was a neutral party for Hayden any longer at that point. So I thought that was an issue. The grades alone, I thought met the Ellis v. Carucci burden, just his grades. We showed how poor they were. We showed how, this was 3/28/2019. So we showed how poor they were. We showed how he didn't have any access to his mom. And it just seemed like the only thing that the judge wanted to have happen, which didn't happen, was, here, Mom, you can have phone calls with Hayden to help him with his grades, to bring up his grades, but she was still being denied phone access for that whole next year with Hayden. So to me, that was another big thing that was overlooked. The legal violations with the therapist, again, the joint legal custody violations between the therapist and between the school, not having access to being on the records, and that was creating huge conflict, which was another best interest factor that the court did not go into. So I think there was also time in all of that. Like COVID was obviously a natural part of the delay, but then also the delay in the child interview report. And so we are almost 2 years at that point in time from saying, hey, judge, something is going on wrong here. We want to modify custody. And it took 2 years to get a no. And the no came, in my opinion, without a lot of support behind it. And so that is why Amber has filed that motion to reconsider. We felt that we met it way back on October 2019. We met all of the burdens, Rooney, Ellis, we met all of those burdens back then. And you can still see that the same problems complained about at that point in time continue to exist today, with the whole withholding of Hayden between December and January 2021. And then you get that
Putting her back in school.
oh, the school issue. Dad decided that he was just going to re-enroll Hayden in school and did not involve Amber in this process.
Yes,
And then
I understand that, but I also read even further down in the history that apparently Mom had done the same thing previously. But I mean, I just read that somewhere. I don't know that that was ever a finding or if that was accurate.
That's not accurate, and I'm not sure where that is, but that's never happened on Mom's part. And so the same behavior continues to happen. That's always been going on since this started years and years and years ago. And now we have a child interview done by FMC, and FMC is not saying that the child is triangulated, that he is on one side or the other, just what Your Honor just mentioned, that he loves both of his parents. He's sick of the conflict. He would like to spend equal time with them. So I don't know. I mean, I do have to say, though, Your Honor, that I am impressed, that my client is impressed how much time that you took to go through the record. This is something that nobody has given her before. She just wanted someone else to look at this and take the time to properly review everything, because when a case is touched by so many different judges, and you know, we know how sometimes it works, that judges rely on the prior law clerk's briefs or the prior judge's notes, and they don't really do the deep dive into it. And we can see that you've done the deep dive, and although we may not like that you are not reconsidering her decision, we thank you all the same for taking the time to look into this.
Well, thank you, Ms. Robinson. I appreciate that. I would also like to say I'm shocked that this case has been touched by so many judges. Y'all told me that, but you didn't even, I still didn't even have, ridiculous. The one family, one judge thing, I mean, I get, you know, there's a lot of other considerations. But holy cow, I mean, I didn't even know there was an evidentiary hearing by Judge Tootin was even involved in this thing. What we had Judge Tootin and, oh my gosh, I think I counted 8 judges total. But then I wasn't sure if it was Judge Gibson or Judge Elliott that was also involved at one point.
And I think there was Judge Hardcastle.
Judge Hardcastle. I mean, it's unbelievable. It's so unfortunate to me that these parties have had to endure that, especially when it's such a complicated case. I'm not complicated, just you know, there's a lot of history, and it is terribly sad, and I feel awful. But that's why I wanted to tell you, I'm really blown away that after all of this, how it seems to me, based on the totality of everything that I've read, that Hayden's a pretty cool dude. I mean, he just seems like he's really got a good head on his shoulders. But that doesn't mean he hasn't been without his pain, I'm sure. But, anyway, thank you for that. Mr. Carmen, I also wanted to say, and I should have said this before you spoke, Ms. Robinson, it is not my role here, because you've asked me to, you know, based on your motion, to reconsider the prior ruling. But if anybody had asked for teenage discretion, it looks like he does want to spend, you know, a little more time with Mom. And so I don't believe it would be appropriate for me to order that at this time, but I would hope that Dad would, I mean, release the child a little bit more to spend time with his mom. If that's what he wanted to, if he wanted to do that, to give him a little bit of discretion. Now, I don't think that teenage discretion means that the child should get to dictate whether or not he's going to go to the other parent's house. I don't think that that would be a good in this case, but I would like, I don't know. I wish that the parties were better at, I don't know. I guess.
I think, part of the issue, Your Honor, is, when we first came before you, it was, it's hard when there's so much history in a case and you have a new judge. It's very hard.
Yes, I know.
To help you. I mean, I hope you understand. The problem with this case is the problem I mentioned to you at the first hearing in front of you. We have perpetual conflict that's affecting this child. And every time we've tried to get a parenting coordinator involved, every time we've tried to get a guardian ad litem involved to actually intervene and fix the underlying problems, it's being thwarted. And it's not before you right now, but I stand by my comments to you the first time we were before you, how desperately these parties need a parenting coordinator. It's easy to portray people in litigation as being bad, evil, but the reality is, despite all the conflict, they're still working together as parents. They definitely have a dysfunctional co-parenting relationship. But just recently, my client offered extra time to the other party. It's not like the litigation is completely obscuring what's best for Hayden. And my concern throughout this whole thing, and why I have kind of fought, Your Honor, and the longer this case continues to go on before the court, the longer that Hayden's going to be caught in the middle of this. This case started, despite all the different judges who have touched it, the history that you just read shows how incredibly lucky these parties were that a motion was filed by Mom way back when. Judge Steele took a lot of time at the hearing to go through the allegations, to scrutinize the offers of proof. Even when she had concerns that the offers of proof and the evidence that was submitted didn't back up a case for a change in custody, she still erred on the side of doing a child interview. The process took longer than expected. But the child interview, ironically, it did reiterate our position at the end of this case. Hayden was determined to be a psychologically vulnerable child. When he was brought in by his mom, he would walk in and be negative against Dad. He'd repeat specific comments that Mom relayed to the reporter. It's a child who's just caught in the middle of this litigation that won't end. And so I hope, I'm kind of apologizing for being such an advocate in this case.
Oh, no, you should not. Neither one of you. I applaud all of you. Initially, remember, I was a little bit frustrated with Dad, for the whole, holding the child for the COVID thing. But, the more I read and dug into this case, I found Mom and Dad to both be more human, and I had more and more compassion for them, both of them, and Hayden, the more I dug through here and read more and more. And I just feel for all of you. No, don't apologize for being an advocate.
And I as well appreciate you taking that time. And it's... Again, when we were here the first time before you, I think I almost laughed at how much I didn't envy the position you were in, because
you underestimated that. You understated that, yeah.
So, but the bottom line is, the one question that's before you is Chris the prevailing party in this litigation? I don't think that a finding that he wasn't the prevailing party would be consistent with the record of this case. But I will also say this, at the very least, the costs of the child interview have to be reconciled. He advanced the cost of that child interview. It definitely was of assistance to the court. Hopefully it's of assistance to the parties, and
I think it was of assistance. However, I think that it could have been handled through FMC. I think FMC did almost just as good a job as Dr. Mullen did, even though Dr. Mullen definitely was more in depth, and you felt more secure about her process because she did have the extended interviews with both parents. But I mean, ultimately, I felt like the results were somewhat similar, and also the arguments were that the child is fragile, the child is afraid of mom, and easily manipulated by the process. That's why we want to take the extra precautions and go through Dr. Mullen. So, no, I don't. I think that was the risk that y'all took by asking for the added protection of requesting Dr. Mullen. And of course, we're doing Monday morning quarterbacking here because we don't know that Dr. Mullen wasn't going to come up with a significantly different interview than FMC at the time. I thought, I don't know. You have more confidence in the process with Dr. Mullen, certainly, but ultimately it didn't bear fruit. That the child wasn't afraid of mom, and that was one of the things I was really trying to get at the bottom of, because initially when y'all came in here and it was on that motion about dad withholding the child over the COVID situation in December. That was one of the allegations, is that the child feels disenfranchised from mom's home because he doesn't feel like he's a member of the family, or he was told that he's not a member, and none of that bore fruit. None of that had any merit. So if you're requesting that the child interview be split, I'm afraid I'm going to have to deny your request. I think that dad should bear the cost of that.
And I guess my only argument would be, I think that Judge Forsberg clearly determined him to be the prevailing party. I think her attorney's fee order reflected that. I don't think there was a clear error on her part, but I mean, obviously I understand you're making your own decision. The motion that was filed has to be evaluated as it was when it was filed. You can't say now, because of a follow-up child interview years later, I just don't see it. And I don't think that the allegations of parental manipulation section of the child interview, without it going through Dr. Mullen, there's no way that she would have been able to notice the different presentation of Hayden when he came in with his dad and when he came in with his mom, and how different his presentation to the interviewer changed. And that's what the one thing I told you about that FMC interview is, taking one interview as a snapshot when mom brings the child in doesn't necessarily give you the most accurate view of what's happening. And I still, I think that if Chris had an opportunity to bring Hayden in for an FMC interview, it may have been a very different situation.
Okay. Miss Robinson, I need an order. If you would please prepare the written order for today. And I'm going to, and I'm denying your request, Ms. Robinson, for reconsideration of the denial of your attorney's fees award previously. I'm sorry. I know. I had a judge do that to me before too, and I was pretty miffed by it, but I'm sorry, I have to deny that. So if you would prepare the order for today, please, and run it by Mr. Carmen, of course, and then I'm going to schedule a follow-up hearing, on a chamber calendar reminder for August 20th at 3 a.m. to make sure that we have the final order here. So obviously you do not have to attend that hearing. That's just a chamber calendar reminder to make sure that we get that order in by that date.
How detailed of an order do you want from this hearing? And I'm just asking because I'm going to be reviewing it. I know Ms. Robinson's going to prepare it. But what are you expecting as far as detailed findings in the order? Well,
see, that's the what is it, $6 million question, isn't it? Of course, I want an order that that will hold up in the Supreme Court if it has to go up there. So I tried to make findings, but so I have no guidance for you.
Okay.
I'm so sorry.
Your Honor, I had one comment and one clarification. My clarification question was specifically in relation to the child's grades at the time of the initial filing of the motion. Did Your Honor have any comment on that? Because I just don't know how to explain that to my clients when that is what the whole LSV Carucci case was about grades.
Yeah, well, as I said, I mean, my role here, I was not in Judge Forsberg's role when she heard the initial motion, or Judge Steele's role. My role was reconsideration of the first order. So I tried to stay focused on that, and Judge Forsberg felt like that there was not a substantial change in circumstances with respect to the grades, because she specifically mentioned the grades, his declining grades. And as you mentioned, holy cow, we're 3 years down the road now? You know, that's just a really long time. Almost 3 years down the road for this motion. Wow. Did you know there's a Supreme Court rule that says that child custody disputes are supposed to be decided in 6 months?
Yeah, they should call it a guideline because it's rarely followed as a rule.
Right.
Oh. So,
And then my comment, Your Honor, was I just hope that both parties will take all of Your Honor's sentiments, take it to heart. I need the court to know that just last night that Christopher called Hayden and was commenting on the child interview and commenting about Hayden's rating of Dad and his former wife Vicky, and
how it's going to change when he gets home.
And how it's going to change when he gets home. And I don't know if that was a threat to Hayden, but these interviews are supposed to be confidential, and these children are supposed to feel like they can be allowed to speak freely. And now I feel like he's getting punished with this, and I just needed Your Honor to know.
well, if that's true, that's disturbing and sad.
I can see from my client's head shaking that he's adamantly denying it. I don't know if the court
I'm
wants
not
to hear
making
from
any
him.
findings. No, this case will be closed after I get the order. So, all right. Thank you very much.
Again, Your Honor.
Thank you. Good
Thank
luck.
you.
Have a good evening. Have a good weekend.
You too.
Court's adjourned.
Thank you. You too, Your Honor.